EQE Shots EQE Paper D2-2022. Welcome to your Euro patent brief journey with Barış Atalay. We're about to dive into the complex but fascinating world of European patent law. Today we focus on EQE Paper D2-2022, a case study that involves multiple patents, opposition proceedings, and strategic legal actions. We will break it down step by step, making sure you grasp the key aspects. Let's tackle this together.
Section 1. The patent situation.
Imagine you are managing a company that has developed a new technology for recycling plastics. You've designed a machine that improves the way plastic waste is processed. Your invention is promising, but now you're facing legal challenges from a former collaborator. To analyze the current patent situation, we need to look at 5 key aspects.
1. The feed machine with a single feeding duct.
A European patent application, TOR-EP, was filed by your former collaborator TOR on the 3rd of June 2019. The problem? This application is based on your confidential designs and technical report. Since it was filed within 6 months before your own patent application, it does not count as prior art against your first patent, OPT-EP1. However, it does affect your later patents, particularly OPT-EP2 and OPT-PCT. Key takeaway: the filing of TOR-EP appears to be an abuse of the secrecy agreement you had with TOR. Legal action may be necessary to reclaim ownership.
2. The feed machine with 2 feeding ducts.
Your company's first patent application, OPT-EP1, claims a machine with 1 or more feeding ducts. It also includes a dependent claim for 2 ducts, which improves plastic uniformity. This 2-duct version is novel and inventive because prior disclosures, including your own public video, only show 1 duct. Key takeaway: your patent on 2 feeding ducts is strong. However, for international protection, you should carefully manage your later applications as they risk losing novelty.
3. The clean feeding process.
You recently discovered a new technical effect. When using 1 duct for powdered filler and another for granulated filler, the machine's blades stay clean. This reduces maintenance costs and improves efficiency. However, you have not yet filed a patent for this clean process. Key takeaway: you must file a patent application immediately before discussing this publicly or using it in legal arguments.
4. The spray water spray device.
TOR has an older patent, TOR-EP Old, from 2015 covering a water spray device. However, this same device was publicly disclosed at a trade fair in Barcelona in 2014. If this prior public disclosure can be proven, TOR's patent should not have been granted. Key takeaway: a legal strategy could involve challenging TOR-EP Old's validity based on lack of novelty due to its prior public disclosure.
5. The feed machine with the spray device.
Your patent OPT-EP2 was the first to describe the combination of FEED and SPRAY. However, it does not claim the spray device on its own. Your international application, OPT-PCT, does claim this combination. Key takeaway: the combination remains novel and inventive, but you need to ensure your international patenting strategy is strong to prevent TOR from taking advantage of weaknesses.
Section 2. Responding to the opposition.
Now that we understand the patent situation, let's turn to the opposition against OPT-EP1. The opponent is a German lawyer, but anyone can file an opposition, regardless of their personal interest in the case. The opposition is based on 2 pieces of prior art. TOR-EP, which discloses a machine with 1 feeding duct. Your own public video showing a machine with 1 feeding duct. What does this mean? The main claim of OPT-EP1, 1 feeding duct, is not novel because of your public video. However, claim 2, 2 feeding ducts, remains novel and inventive. Recommended strategy: amend the claims to focus on the 2-duct version, FEED-2. Argue inventive step, highlighting the surprising effect of better plastic uniformity. Do not mention the clean process, as this could destroy its future patentability.
Section 3. How to improve the situation.
To strengthen your legal position, you can take the following steps. Reclaim ownership of Tor EP. Since Tor EP was filed using your confidential information, you should initiate entitlement proceedings in Italy. Secure the clean process patent. Before discussing it with investors or using it in legal arguments, file a new patent application for the clean process. Invalidate Tor EP old. To challenge Tor's spray patent, you need to bring the Barcelona fair disclosure into the appeal proceedings. This requires filing a national court case and intervening in the appeal. Strengthen your international patents. When entering the EP phase of OPTPCT, remove claims that are not novel, like the single duct machine. Keep claims for the two-duct machine and the feed plus spray combination outside Europe.
Section 4. Stopping Tor from competing.
Once you take these steps, what can you prevent Tor from doing? If you win the entitlement case for Tor EP, you can stop Tor from making or selling any feed machine with one or more ducts in Europe. Once OPTEP1 is maintained in amended form, you can stop Tor from making the two-duct version in Europe. By securing the clean process patent, you can stop Tor from using this process worldwide. By successfully challenging Tor EP old, you can freely use the spray device.
Conclusion and next steps.
Let's take a moment here. Pause and breathe. We've covered a lot today, from understanding the patent landscape to strategic responses and legal actions. The key lessons: protect your inventions strategically. File patents before revealing new technical effects. Monitor competitor activities. Entitlement cases and oppositions can make or break a business. Patent strategy is global. A European patent might not be enough, so think internationally. In the next session, we'll explore how to draft strong patent claims to maximize protection. Thank you for learning with me, and I'll see you in the next session.